Good afternoon. This segment of our Secure Act webinar, we're going to talk about the Secure Act provisions for retirement MEPs, retirement multiple employer plans. After 7 years of uncertainty and no uniformity from the IRS and the Department of Labor, the Secure Act is now clarifying that both the tax code and Title I are amended to define certain MEPs to be treated as single plans. You may remember in 2018, there was an executive order that required the IRS and the Department of Labor to issue MEP guidance, and the agencies did that, at least in proposed form from the IRS, and we'll be looking at how some of the new Secure Act rules will fit in with the existing guidance from the agencies. The new Secure Act provisions apply to both association plans, the plans that have been around, multiple employer plans under Title I of ERISA for decades, and adds a new type of multiple employer plan, an unrelated employer arrangement with a pooled plan provider. And the Secure Act provides bad apple rule relief for both of those two types of plans. And the IRS is required to create a model plan, and these provisions will be effective for plan years after 12/31/2020. The driving force for the Secure Act was to encourage and stabilize the use of MEPs for small and mid-sized employers by removing the rule under 413C of the code, under which the disqualification errors of one participating employer could disqualify the entire MEP. Now, certain MEPs will have a method to require all participating employers to comply with the tax rules and the Title I fiduciary rules, and placing the responsibility and consequences on noncompliance solely on that employer. Now, just a word before I talk about the new rules, I just want to say ERISA Title I MEPs have been around for years, and the tax code amendments and the Title I amendments only refer to plans, these association plans, as plans maintained by employers with a common interest other than having adopted the plan. And we're just going to assume that this refers to the current DOL definition of an association plan. It's been around for years, recently codified by the Department of Labor, and but still it's going to raise the question if these existing DOL rules for associations will still apply. We'll also look at the new DOL safe harbor for PEO MEPs to see how it meshes with the Secure Act. The major new development is the pooled plan provider. And what the new rules the Secure Act provides is that a retirement arrangement for multiple unrelated employers with no common interest, what used to be called an open MEP, if there is a pooled plan provider, it will be treated as a single multiple employer plan for both code and Title I purposes. And these new rules will treat all participants as employees of one employer, with small exceptions, and uses the MEP provisions in ERISA 210A and the Internal Revenue Code 413C. Now, the pooled plan provider is going to be the named fiduciary, the plan administrator, who acknowledges in writing its status, and then further down the road, when they're filing 5500s, has to make sure that the Form 5500 identifies the pooled plan provider and provides other information. And the pooled plan provider is responsible both for the MEPs and the employer's compliance with the code and Title I. And there will be lots of new disclosures to be required of the participating employers and the pooled plan provider. Just shortly, and you will be seeing lots of this in the coming year, the pooled plan provider will register with the agencies, be a named fiduciary, plan administrator, responsible to ensure proper bonding, and making certain disclosures to participating employers. One question that really needed clarification, and which has troubled legal scholars on all MEPs, particularly since 2012, is which entity is responsible for the participating employer's portion of the plan? Is it the employer who is establishing and maintaining the plan, or is it the MEP operator? And the Secure Act answers that question by saying that participating employers remain the plan sponsor of their interest in the plan, except to the extent of the pooled plan provider's required administrative duties, including ensuring that all employers and the MEP are in compliance with the code in Title I. And what's interesting is the Department of Labor and the IRS share guidance authority to identify the administrative duties required of the pooled plan provider. Now, here's the bad apple fix, what the IRS calls the Unified Plan Rule. The Secure Act now provides that the MEP's terms must require that the plan assets attributable to an employer who fails to comply basically with the statute, but with the reasonable terms of the plan and the new regulations, that the plan assets must be spun off to an existing or new plan of the employer, and the employer becomes completely liable. And the agencies are given the authority to define circumstances which, when it is appropriate to require that the MEP actually retain those assets instead of spinning them off. And that is a clarification from existing practice. And one of the things that's very important about the Secure Act is both the code and the Title I provisions give employers and pooled plan providers a grace period. Employers and pooled plan providers who comply in good faith with a reasonable interpretation of the new provisions may operate before the agencies issue guidance. And, you know, particularly for things like the new pooled plan providers reporting obligations, the 5500 form is a tri-agency process and very lengthy. We can assume that the Department of Labor will give some kind of interim guidance and a non-enforcement policy so that within the less than a year before pooled plan provider plans can start to operate, these plans will have some guidance as to how to operate before the regulations are final. One important thing that is solely the responsibility of the IRS Treasury, the Secretary of the Treasury will determine whether the pooled plan remains a single plan if the pooled plan provider fails to comply with any requirement. One of the things that you'll see if you decide to read all of these provisions is that there are lots of caveats and warnings and protections, both for the participating employers and the employees of the participating employers. In fact, there are a number of provisions in the Secure Act that kind of reiterate existing law, as if that these provisions need to be re-emphasized. Now, the provisions, the amendments under Title I of ERISA, provide more information about what the terms of the pooled employer plan have to be. And these do not apply to association plans. These only apply to the pooled employer plan that has a pooled plan provider. One of the things, it's just a little hint back to the employers, they will retain at least some residual investment responsibility unless it's delegated to another fiduciary by the pooled provider and is done in compliance with 404C or is done in compliance with 404C. The Title I amendments also require that the pooled plan must provide that employers and participants and beneficiaries are not subject to unreasonable restrictions, fees, or penalties with regard to ceasing participation, receipt of distributions, or otherwise transferring assets of the plan. You could see from this provision in Title I that there have been some difficulty in exiting from these plans, both for the plan sponsor, the employer, and for the participants receiving their benefits. The Title I amendments also require that the pooled employer plan designate one or more trustees, other than an employee in the plan, to be responsible for collection of contributions and for holding the plan's assets and implementing contribution collection procedures that are reasonable, diligent, and systematic. Again, you can see here that there have been problems with delinquent contributions in multiple employer plans, and as you probably know, this is a very important issue for the Department of Labor. The amendments to Title I also emphasize that each employer in the plan retains fiduciary responsibility for the selection and monitoring of the pooled plan provider. Because the pooled plan provider and the pooled employer plan are new concepts, there are going to be questions which will arise from existing guidance from the agencies. For instance, under existing DOL guidance, commercial entities are not permitted to sponsor an AHIP, which is the Group Health Plan, Association Plan, or an association retirement MEP. Under the new DOL guidance, commercial entities may only sponsor the PEO retirement MEP under its regulations. Now, the pooled plan provider is likely to be a commercial entity, so there's going to be questions about whether existing PEO MEPs will become pooled provider plans or how the existing DOL guidance will mesh with the Secure Act. Questions about how ERISA 408B2 will apply for plan level disclosures and also for participant level disclosures. And does each participating employer approve the pooled plan provider fees, or is more going to be required? The other question I think that people are talking about is, can a commercial pooled plan provider use its own investment products? Are the existing exemptions sufficient, or will the department have to consider providing new exemptions? Pooled plan reporting. Now, you may remember when Congress first turned to the MEP questions, it amended Title I to require new reporting for all MEPs. And the DOL reporting rules were changed to require that any multiple employer plan had to list the participating employers and include both employee contributions for that year. And one of the things that's later in the slides, in 2019, in a Field Assistance Bulletin, 2019-01, the Department of Labor announced that it had been monitoring MEP compliance with the Form 5500 and found pretty major noncompliance for all MEPs, including PEO MEPs. And it declared a non-enforcement policy. If MEPs came into compliance, then the Department of Labor would waive penalties and fees for non-compliance for filing from 2014, 2015, and 2016. There's similar pooled plan reporting in the Secure Act, very similar to what was enacted in 2014. Listing all employers has to identify the pooled plan provider, give a good faith estimate of the percent of contributions made by each employer, that is employer and employee contributions, and a new rule, aggregate account balances attributable to each employer. One of the other things there's very little guidance on, and the Department of Labor, I'm sure, is busy. The Secure Act amended Section 104 of ERISA to permit the Department of Labor to permit pool plans to file simplified reports if the plan is under 1,000 participants and no single participating employer has over 100 participants. How this is going to be interpreted remains to be seen. No doubt it will be issued for proposal first, but current DOL regulations waive the auditor's requirement for certain plans under 100 participants and query whether this will apply. And there are going to be other questions. Does the size limit mean that the large employers in the pooled plan must file separately with an audit, or the pooled plan itself will not even qualify for simplified reporting, or will the pooled plan have an audit covering all participating employers? There's an alternative. So after the passage of the Secure Act, if an employer is interested in a multiple employer plan, they could join an association plan, a PEO plan, or the new pooled employer plan. As one alternative, the Secure Act provides for additional group annual reporting for employers that still maintain their own separate single plan. And so Title I and the code were amended to permit these unrelated employers with separate plans, if they have common fiduciaries, trustees, and investment options, to file a single Form 5500 by a common plan administrator. It's not clear whether there'll be a single audit report selected by the plan administrator, and the Department of Labor and the IRS must issue the necessary and appropriate regulations. And there are commentators that are touting this alternative to one of the more complicated MEP arrangements But these are single plans. The employer would still be responsible for establishing, maintaining the plan, and all of the fiduciary obligations. One thing to note, the Secure Act increased reporting penalties under the code to $250 a day. No increase in the Title I penalties, but those penalties are pegged to inflation anyway. Now, just want to run through the recent Department of Labor and IRS guidance because throughout this year, the new Secure Act rules will be examined and re-examined as to how they apply to the existing, especially the current guidance, and how the agencies are going to deal with this. There were a number of things. First, the definition of an association plan. The DOL issued a regulation in 2018 for association plans that provide group health insurance. This is called an AHIP. Same definition of association as in the association retirement plan. And then in 2019, along with the association retirement plan, the DOL issued a safe harbor for PEO MEPs. The DOL also issued an RFI on open MEPs. Those are unrelated employer plans, which the Secure Act now regulates. And then, as I mentioned, the DOL FAB 2019-01, conditional reporting relief for all MEPs, including the PEO MEPs. And then the IRS in 2019 issued proposed bad apple regulation or unified plan regulation, proposing ways that a MEP operator could involuntarily terminate a non-cooperative or non-compliant participating employer. So I will run through these quickly because there have been some developments in the past year. The DOL AHIP reg, which contains a definition of an association plan very similar to the DOL Association Retirement MEP, but changed and liberalized the definition of an association plan, and it has been in litigation by several states who challenged the regulation. There was an oral argument before the Court of Appeals for the District of Columbia in December, and this is, we're not going to read the tea leaves, but the Court of Appeals, the judges seemed inclined to approve of the new association plan definition using a Chevron standard, including one of the elements of the association group health plan and the association retirement plan, that the plans could include working owners. And so the fact that the AHIP regulation may appear to be at least on track to be upheld, that will provide some stability to the DOL's association MEP because it was called into question. And I'm going to go through these rules quickly. They've been out for a while. The DOL's retirement MEP regulation defines ERISA 3.5 employer for multiple employer defined contribution retirement plans. These are the retirement MEPs. And that is ERISA 3.5 definition of employer includes a group or association. And the new reg provides new guidance. It supersedes all prior DOL sub-regulatory guidance on the bona fide employer associations. And it also, as I said, provides a new pathway for PEOs to establish a MEP. And its effective date was September 30th, 2019. You could see how close the Secure Act came on the heels of this regulation. And so you will have plan advisors, if you're a plan or an employer, already talking about the new DOL regulations, perhaps moving in that direction. And now you can factor in the new Secure Act as well. Just briefly, the employer association MEP, retirement MEP, employers have to have a commonality of interest, substantial business purpose other than just providing benefits, and have control over the association and the MEP. The DOL emphasized that the group or association can't be a commercial entity, even though if you'll see in the preamble, it sort of says that's always been the rule. So it's stating a rule that's always been a rule, but here it is again, and provides that for the first time for both the association retirement MEPs and the AHIPs, the association group health plans, that working owners with no common law employees may participate as employer and employee. So the other part of the Department of Labor regulation is the bona fide professional employer organization. You'll have to read the regulation. There's lots of different rules and requirements on the PEO. This is the first time the Department of Labor has announced a definition of a PEO plan as a single multiple employer plan. And it defines what PEO is broadly: human resource organization that contractually assumes certain employer responsibilities for the workplace client employers, and it performs substantial employer functions and maintains adequate records. And one of the differences in the DOL reg is that the DOL reg pretty much provides that the PEO is the plan sponsor, in addition to being the plan administrator and the named fiduciary, and has employee benefit obligations to the MEP employee participants after the client employer no longer contracts with the PEO. And I think we'll find this is different from current practice, and more in line with the way the Secure Act deals with when an employer is no longer in a relationship with a MEP. And the PEO is required under the reg to ensure that each employer has at least one direct or common law employee who is a participant covered under the MEP. And unlike association retirement plans, there are no working owners in the PEO MEP. There were still open questions after the DOL issued its regulation. For one, the Department of Labor had issued an interpretive bulletin permitting states to establish and maintain ERISA-covered open MEPs. Query whether that will still be a valid avenue. There's going to be an open question about PEO plans, now clearly defined as MEPs by the Department of Labor, both in the FAB and in the regulation, but for retirement MEPs only. So there's an open question about whether the PEO can sponsor a group health plan where the DOL AHIP regulation excludes these commercial sponsors. One of the things about the DOL preamble to the retirement MEP regulation, it offers pretty specific guidance on the fiduciary rules for the MEP and the participating employer when the relationship is terminating, including, under some circumstances, the assets remaining in the MEP, which may be different from some current practice. But the DOL preamble and its rules are noticeably silent on the ability of a MEP operator to involuntarily spin off and terminate the portion of the plan that's attributable to a non-compliant participating employer. Now, the DOL, simultaneously with its retirement plan MEPs, issued an RFI, Request for Information on Open MEPs, which is the loose definition for the plans that the Secure Act now regulates. So likely is they don't need to continue on with this RFI and do guidance on this, even though undoubtedly there will be Secure Act guidance that will reflect some of the concerns that are listed. But what the DOL said was, in our retirement MEP regulation, we didn't have enough information to allow open MEPs, but tell us what you would like to see and what we can do. And there are some open questions in the DOL request for information. And these are issues that have begged for clarification for many years. And very possibly the DOL will be able to provide an answer either through informal guidance, advisory opinions, or perhaps when they do their guidance under the Secure Act. One of the questions is, could the DOL's rules permit corporate MEPs? These would be a defined contribution plan that cover employees of employers that are related by some level of common ownership, which is a substantial common interest, but are not enough ownership to be in a control group. The other question that's been around for years is whether members of an affiliated service group, that's within the definition of 414M of the code, should that group be treated as an employer within the meaning of 3.5? In other words, could an affiliated service group be a type of association plan? Now, I mentioned that the Department of Labor issued reporting relief in 2019. It's DOL Field Assistance Bulletin 2019-01A. If you're an existing MEP, you've already come into compliance, and it's very similar to the type of reporting that now is going to be required of the pooled plan providers. But all MEPs, and that is the association retirement MEPs and the association group health plans, the AHIPs, will be will be complying with the existing rules for the time being. And what the DOL said, and it just goes to show that the Department of Labor is actually looking at who's reporting and was looking at MEPs through this whole period of time. What they found in a review of the 5,500 data, that MEPs, including PEO MEPs, were not properly completing out the required information. And this is a statutory requirement created by Congress when it first started looking at MEPs. So the DOL took it seriously, but said there was enough confusion and enough good faith compliance that they were going to give reporting relief. And what they decided to do was these are the requirements: making a list of your employers, good faith estimate of the contributions. But here's the relief. The Department of Labor announced that it wouldn't reject a MEP form for the 2017 plan year or any prior plan year, or seek to assess penalties just because the plan administrator failed to fill out the annual report compliance for MEPs, and provided that the annual report filed for the 2018 and following years included the necessary and complete information. Now, as I mentioned, there was an executive order that required the Department of Labor and IRS to issue guidance to clarify and provide some kind of guidance for MEPs, both existing and in the future, on how to deal with some of the issues like the bad apple issue. And the agencies complied. The IRS issued a bad apple proposed regulation, and this is designed to provide clarity on how a MEP operator could involuntarily terminate participation in the MEP of a non-compliant participating employer. And these are all the DC plans, and the IRS regulation is under 413C of the code, which is the same provision that's now been amended by the Secure Act. And just what was interesting, the IRS had a hearing on December 14th, 2019, and even though probably some of this regulation has now been superseded by the Secure Act, there were lots of comments on the proposed regulation, and I'm sure that some form of the IRS proposed regulation will be a part of their future regulation. In the hearing, speakers expressed much interest in not requiring the MEP operator to actually spin off before terminating the plan of a non-compliant participating employer. In other words, there was lots of comments that said, just let us terminate the plan and make distributions to the employees. There were speakers that requested that employees of non-participating employers would be allowed to remain in the plan. And this seemed to be particularly important because some of the participating employees had worked for more than one employer in the MEP. There was also a lot of interest in having the MEP rules, the bad apple relief provided to defined benefit plans as well. The IRS seemed more reluctant to consider that possibility, at least under current guidance. So the bad apple proposal, and you'll see some elements that are very similar to the Secure Act. It provides for spinning off and terminating from the MEP. It could be initiated by the participating employer and implemented by the plan administrator, or implemented unilaterally by the MEP plan administrator. The interesting thing about the IRS bad apple proposal, just like the Department of Labor's final retirement MEP regulation, they both mentioned in their preambles the fiduciary issues. And that's one of the things that the Secure Act provided the agencies with the authority and some guidance on how to define the fiduciary aspects of both the pool plan provider or the association and the participating employer. And the IRS said it right out in its preamble. It asked for comments on how the Department of Labor should take steps to facilitate the IRS proposal, noting that the DOL had informed the IRS that MEPs using the spin-off termination guidance should be concerned about fiduciary and potential prohibited transaction issues. So many of the issues raised by the Department of Labor regulation and the IRS bad apple proposal have been answered by the Secure Act, and the agencies now have the authority to make some of the hard calls that they need to make so that these plans can operate in compliance with both of the laws. So that concludes the presentation on this for today. You will be hearing lots about the existing retirement MEPs, the DOL Association Retirement MEP, the DOL PEO plan, the new pooled plan provider MEP, and if you're in an existing MEP or considering it, you will be hearing about these things and how the Secure Act is going to impact what the existing guidance is in the coming year. So thank you.